Thank you, everybody, for joining Meltzer Hellrung's October webinar, U.S. visa processing and year-end travel, as well as updates on the H-1B visa fee and other things that are going on in immigration. We will go ahead and start here in about 3 minutes. Okay, it's been about 3 minutes, even though our counter here seems to be stopping. So we'll go ahead and get started. Thank you, everybody, for joining us today for Meltzer Hellrung's October webinar, U.S. visa processing and year-end travel, what employers need to know. We'll also be covering updates on the various H-1B rules and other enforcement activities. We have about an hour set aside today to talk about it. We have a Q&A function. If there's questions throughout the webinar, please feel free to type in the Q&A function. Mike and I will try to get to them as quickly as we can. Anything that's left over, we'll follow up on. And as always, if you have a specific question, the information we're giving here today is not legal advice. It's meant to be general information. Hopefully you find it valuable. If you have a specific legal issue, please reach out to us. Either via email, which we'll share at the end of the webinar today, or on our website via Contact Us. And as a reminder, the webinar is being recorded today, so anybody that registers will receive a recording as well as the deck we're using right now. So a little bit about us at Meltzer Hellrung. We pride ourselves in combining an innovative service model to deliver our legal services, our proprietary immigration technology, Voyager, and a really creative team of immigration attorneys and paralegals who are working really hard right now to provide unique solutions and tailored solutions to our clients. A cross-section of our book of business looks to be about 200 active corporate clients at any given time. And we have clients in the Global 200, Fortune 500, as well as venture-backed unicorns in various industries, including AI, robotics, drones, SaaS. We were recognized in 2023 by Crane Magazine as one of the 100 best places to work in Chicago, which we're really proud of. And most recently, we have been recognized by Illinois Chamber's Spotlight 2026 guide as a top law firm handling immigration work in the state of Illinois. About our service model, how we differentiate ourselves really here, we really pride ourselves in being responsive and responding to emails in about 4.5 hours during a business day. We are really efficient in turning around your transfer cases so that you can get those new employees onboarded as quickly as possible and working for you. We are very feedback focused in that we ask for feedback from every case we process for a client and for a national employee. We use that to build our service and certainly to provide the best immigration experience possible. And then we don't just process cases for our clients. We really focus on partnership and program management, where you have an assigned dedicated account team, regular touch points to manage your immigration program, as well as all the data that we collect in our platform, Voyager. A little bit about myself here, excuse me. I've been speaking for the last few minutes. My name is Meltzer Hellrung. I'm co-founder and managing partner of Meltzer Hellrung. I specialize in scaling immigration programs for our high growth clients. This usually involves immigration policy creation, stakeholder training, and I've represented clients in dozens of industries, including information technology, engineering, education, manufacturing, software, AI, robotics. With me today is our senior counsel, Michael Tarancic. Mike, you want to introduce yourself?
Sure. Thank you, Matt. And thank you all for joining us today. As Matt said, my name is Michael Tarancic. I'm senior counsel here at Meltzer Hellrung. I have been working in the immigration field for over 30 years. I've worked at large firms, I've worked at small firms, and I've represented literally the entire array of corporate employment-based immigration clients, from startups and entrepreneurs to Fortune 100 companies. And I'm happy to be here today. There's no shortage of things going on in the field of immigration law, and we will start talking about them shortly.
Sure. Thanks, Mike. A little bit about our proprietary immigration management platform, Voyager. This is the one single source of truth that we use in representing our clients. Get all of your immigration information about all their employees, dependents, even for those individuals who may not sponsor, into the platform, and that drives certainly efficiency through dashboard transparency, efficient workflows that we have customized to cases. We have an extensive immigration reporting function, which is helpful right now. If some of the things we're talking about today, you can pull your own report very quickly and see who's been affected in your population. And then we always strive to educate the employees that we work with, the entrepreneurs, the investors, as well as the human resources, people ops folks, general counsels, by providing the best information we can via knowledge center in the platform, as well as that has our blogs, our webinars, and immigration collateral for the various visa types that we handle. If you're really enjoying our webinars, I want to point out an opportunity to get weekly updates from us. We do webinars monthly. We're going to continue to do them monthly. I think there's a lot of things happening. Pulling them into one specific sort of half hour or an hour time period seems to be the most efficient. We do know that obviously things happen from month to month that you may need information on or want guidance on. So here's the opportunity to register for our newsletter. You can also go to our website and register for our newsletter there. This is a weekly update where we summarize all of our immigration, everything that's going on in immigration every week, and send it to you every Friday afternoon, so you can read over it and feel up to date if you're handling immigration day to day. Our agenda today, we're going to talk about the most recent breaking news, which is the 540-day auto extension for EAD cards. It was just announced today, which might publish tomorrow, I think. Is that right?
Correct.
We're going to take a brief overview on an update on the H-1B filing fee. There's some updates there from last month. Increased DOL scrutiny for H-1B employers, which is coming. And then we'll get into the meat of today's webinar, which is consular processing. For the holidays here, third country consular processing, in-person consular appearance requirements for those folks that are going abroad and getting new visa stamps when they travel. And also, visa reciprocity changes and how that affects fees and business travel going forward. Mike, do you want to start with the update that's top of mind here, which is rescission or the 540-day auto extension by USCIS?
Yeah. Thanks, Matt. I will. I have to say, as I said at the outset, there are no shortage of changes in immigration law, and this one appeared in my email inbox around 7:30 this morning, which was a USCIS announcement that it will be publishing in the Federal Register tomorrow an interim final rule effective tomorrow, eliminating the practice of providing automatic extension periods for EADs or authorization for up to 540 days. So this is a rule now. It's a regulation that has existed for some time, and it was primarily done for mutual benefit. The agency just was overloaded with applications. Their backlogs were getting longer and longer, and rather than face numerous lawsuits compelling them to issue work authorization, they granted this blanket 540-day auto extension. Now, as of tomorrow, that 540-day extension will no longer exist. It will still be applicable to individuals who had filed applications before the effective date. And I will just note now quickly that it is possible to file an EAD extension today online. So if you have a foreign national employee who, for example, is an adjustment of status applicant and is within the 180-day window for filing and has not filed, they can file today and still take advantage of the 540-day auto extension. But if they wait until tomorrow, they will have no extension. It goes from 540 days to 0 effective tomorrow. So as it says there on the slide, the primary impact are for refugees, asylees, adjustment of status, EADs, spousal employment pursuant to E1 or E2 status, as well as those H4s who have work authorization, those spousal EDs. There is a longer list of individuals who are affected by this interim final rule that's in the regulation. But for purposes of this call, and because most of you are more focused on employment-based immigration issues, those are the primary categories that are going to be of most relevance. Now, as it says there, there's a separate rule that provides for interim work authorization, 240-day auto extension for H's, L's, and E's. That is untouched. That is not referenced at all in the 70+ pages of the regulation that were put out this morning. So that remains valid, and those individuals will still have their auto extension if it's necessary. So, and for the primary, I think, impact right now, there is for I-9. So if you have individuals who have a need to re-verify their work authorization after tomorrow, the 240-day rule will no longer apply if the extension is filed after today. There is guidance. It's already been updated on I-9 Central. That happened just a little while ago. So there are new instructions available for employers about how to complete re-verifications in these circumstances. So what
so
else?
Mike,
Yeah, go ahead.
In this instance, it's safe to say the crux of this issue is that USCIS is processing EAD cards too slowly, and you can only file for them 180 days in advance, but it's taking 200 or more.
Correct.
That these individuals will no longer be work authorized in that short period where their current EAD expires and an extension has been timely filed. Now, ones that are already in process, yes, but anything hereafter, no. Is that right?
That's correct. I think that the concern is that there will be gaps in employment authorization because of the delays, and this will mean that employers may have to take individuals off payroll for some period of time. It'll also mean that there's a possibility that some foreign nationals may consider suing the government for the extended delay and trying to compel them to adjudicate the applications more quickly. In the regulation that's going to be published tomorrow, there was an extensive discussion about the fact that much of the delays derive from the expanded use of the parole program under the prior administration and the numerous TPS categories that existed in the prior administration, and the fact that the current administration has done away with most of those, or a large number of them, is, in their opinion, a reason not to have a 540-day, because they just don't believe the same volume will exist going forward. Now, that's purely speculation, and obviously, reasonable minds can disagree about that particular position, but that's part of their justification for this rule. The other part is that USCIS is not a benefits granting agency. It's now an enforcement agency, according to the new leadership, and that this 540-day auto extension allowed individuals to circumvent the vetting and screening procedures that normally exist for other applicants by virtue of this auto extension. So I think what this emphasizes is that it's really important for applicants to have a valid underlying status. So if you're applying for adjustment of status, it's one more reason why it's really important for everyone, particularly an H-1B, to maintain their H-1B and maintain that H-1B work authorization to help bridge any potential gaps in an adjustment of status EAD. And also, it really emphasizes the need to file as soon as possible on the 180th day. I don't have any.
Completely agree.
Yeah.
And Mike, I mean,
go ahead.
From a program management standpoint, using whatever technology you use and councils you're working with, so that's really important to track anybody that works for you on an immigration benefit, not just one that you sponsor like an H-1B or an L or E that you pay for. A lot of these H-4 spousal EADs kind of fly under the radar in your I-9 process because it's not something that you pay for and they already are work authorized. So again, I think it's really important to track every single person that's on an immigration benefit in your entire company and use some type of software or spreadsheet to make sure that all those folks are covered and you're aware of them going forward.
Yeah, and I actually was just on a call with a client a couple of hours ago, and they're looking at their status report for their individuals who have an adjustment of status EAD or their H-4. They don't have any E's, they don't qualify, but they have H-4 individuals on their payroll, and they're taking a hard look to see what they can do for them, if anything, today.
Yeah. It behooves cutting companies to also track folks that are perhaps legal permanent residents, just because they also face immigration scrutiny right now. We're going to switch gears here a little bit, and Mike, talk about an update on the $100,000 H-1B fee.
Well, what would a webinar about immigration be these days without a discussion of this $100,000 fee? It is the top topic of conversation within the immigration world in the U.S. and even abroad, as I talk to some of my colleagues who work outside the United States. So there are two important updates from last month, which I want to talk about for just a couple of minutes. First of all, there's another lawsuit that's been filed. The U.S. Chamber of Commerce, a large national organization of thousands and thousands of employers in almost every industry and almost every jurisdiction in the country, filed a lawsuit in the District of Columbia, and in the District Court for the District of Columbia a week ago last Friday, essentially challenging the $100,000 fee as illegal on both constitutional and statutory grounds, and also highlighting in very great detail the significant damage that it will do to the U.S. economy. Now, the U.S. Chamber, which is headquartered in D.C., could really only file in the District Court of D.C., which is not necessarily the most favorable jurisdiction for immigration legislation, but they certainly have enough bandwidth and scope to make a strong case here. Also, I want to highlight they actually just, I think just a few days ago, maybe it was just last Friday, a co-plaintiff was added to this suit. The Association of American Universities joined as co-plaintiff on this suit, and it's an organization, I think, based in Washington as well, that has many of the United States' top research institutions as members. So they're here, they're making the same complaint, and they're also showing immediate harm by the fact that they've alleged that their members are putting on hold any future hiring because of the impact of this $100,000 fee. So that is, I think, important. It's also important to note that the U.S. Chamber of Lawsuit actually addresses one of the issues in that initial lawsuit, in that it broadens the scope of potential plaintiffs. The first litigation was kind of narrow in its scope. It had very discrete groups of plaintiff organizations. And there was some concern, I've talked to some of the lawyers involved in the litigation, that the agency might try to remove some of them through its policymaking and make their complaint moot. Well, they can't do that now. They can't do it. The U.S. Chamber is such a large umbrella organization that there's no way that any procedural option could exist to try to oppose the injunction. So let's maybe move on. I keep going. So the other piece of news in this area is that on, I think it was October 20th, USCIS published its first sort of detailed guidance on the 100,000 K fee. It was published on the agency website without notice. It was something that, we as lawyers had to go find. And it provided, I think, really important guidance in terms of the implementation of the fee. It applies, and I'll just go run through some of the key highlights of the guidance. It clarifies that the fee applies to new H-1B petitions that were filed on or after September 21st, which we already knew, but then it clarifies it that it's petitions filed on behalf of beneficiaries who are outside of the United States and who do not have valid H-1B visas. So if you're outside the United States, you do not have a visa, you're applying for consular notification, then the fee will be applied to you and you'll have to pay the $100,000 fee before the visa can be approved. It also provided some interesting further clarification that if you're in the United States and you apply for a change of status or a change of employer extension of pay, then the fee must be paid before the petition, and then you can apply abroad. So if, I'm sorry, to make it clear, if they deny the petition, then you must pay before the petition you can apply, the petition can be approved and you can apply abroad. So if a change of extension is approved, the fee will not be required when the individual applies for the visa to U.S. consulate. Let me say that a little bit more clearly. If you apply for an extension or a change of status and it's approved, the fee is not going to be charged and on the approval of the petition, nor will it be charged when you apply for the visa abroad. And it appears that will be the case, presumably as long as the foreign national has valid H-1B status in the future. However, if the agency denies the change of status or extension of stay, it will deny that part of the petition and then likely issue a RFE request asking you to pay the fee before the petition can be approved for consular notification. Let's move on. If we can move to the next slide. Okay, so again, to summarize, who does not have to pay the fee? The fee does not apply to existing H-1B visa holders or renewals for valid H-1B visas, petitions filed before the effective date, or amendments or extensions approved while the worker remains in valid H-1B status. So what that means as a practical effect is that individuals in the US in legal status can avoid payment if a change or extension of stay is approved and they maintain valid status. So that's really important piece of information that we frankly were not necessarily expecting from the agency. So that provides an option for example, students, F1 OPT students. So
Mike, so
yeah, go ahead.
I would qualify here, that again, there's litigation that may enjoin this from taking effect, but it seems like, procedurally, we talked about this as a team, our attorney team yesterday, and it just eliminates the ability to file for consular processing because you will inherently invoke that fee going forward, but there's lots of ways around that procedurally when we file H-1B visas, for example, change of status inside the United States. We even talked about the option of perhaps bringing somebody in on B1 and then filing a change of status rather than doing a consular processing case with H-1B and then incurring that fee. So I would highlight there's kind of counter move here, cat and mouse game going on between the USCIS and the legal community around how to get around some of this, even though they are providing additional clarification at this time.
Right. And we're looking at some of those options. I think, at the end of the day, the USCIS holds the sort of trump card, pun intended, in that they can deny an extension or change of status request as a matter of discretion, and they don't have to show a lot of justification for that. I do want to highlight here is that this guidance really narrowed the scope of the presidential proclamation. If you go back to the White House and that announcement in the Oval Office, it was a much broader travel ban than what is now in existence pursuant to this guidance. You have to ask yourself kind of why. And my perspective, and it's just my perspective on this, is that the agencies were blindsided by this. They really did not have a chance to look at this, and they were given this sort of large, amorphous, somewhat poorly worded presidential proclamation. And frankly, I think USCIS, and particularly the leadership of USCIS, has been trying to figure out a way to sort of restructure the proclamation in a way that would survive judicial review. And I think that's where we are right now, which this current iteration of the presidential proclamation is as close as I think they can reasonably get to something that might look like a travel ban to a judge. I don't think it does. And one of the reasons that I think is most problematic for that is that they're requiring that the $100,000 fee be paid before you file the H-1B petition. And we'll get to that in the next second. Let's move the slide.
Yep.
Okay, so the next slide is really just how to pay the fee. So this guidance also gave instructions that the fee must be paid through the pay.gov website before filing. So before you file your H-1B petition, before you go to consular processing, you have to file this petition, file this application request for the $100,000 fee through the pay.gov website. There's a link there that gives specific instructions on how you do that. And you get a receipt essentially that you have to provide with the petition. The guidance also makes it clear that as of the effective date, if you do not follow this procedure and you're within the class of individuals who is subject to the fee, your application won't be rejected or an RFE won't be issued. It will be denied. So that's the current status of the payment. I will say, and maybe let's move on to, and I will come back to this. We'll come back to this in a minute, but let's move on to the next slide.
One second.
Because it talks about I want to just highlight in the presidential proclamation, there was a reference to a national interest exception to paying the fee, and that it would apply to industries or companies or individuals. And it was very broad in its language. And I think a lot of immigration lawyers thought this might be a viable path, for nonprofits and other H-1B scenarios where the individual was doing something that could be argued in national interest to find a way around the fee. Well, the guidance that came out on October 20th, I think, has severely constrained, in my opinion, severely constrained the ability for petitioners and employees to obtain the national interest exception, because it's going to be granted only in rare cases, and that's the language of the guidance, which there are no qualified U.S. workers available, which raises the question of how you establish that. The foreign national poses no security risk. Well, that's probably going to be not hard for most applicants. And that requiring payment would undermine U.S. interests, which I frankly don't know what that means. I think you can argue that a lot of different ways. But I think the point being here is that USCIS leadership and the individual who's the head of USCIS right now, Joe Edlow, has on many occasions indicated that he believes the H-1B is really only for the best and brightest. So my read of this is he's not intending to grant this national interest exception only in the most extraordinary circumstances. So I think it's something that we will look at if we have to, but I don't think it's something that will be as useful as maybe we thought a couple of weeks ago. Go ahead, the next slide.
Yeah, 1 second.
Yeah.
Answer, we've got quite a few questions here.
Oh, yeah.
I'm just taking care of most of them right there.
Okay, no worries.
So go ahead, Mike.
So the last thing I wanted to highlight here is that within the last several days, we've actually heard reports of the USCIS issuing RFEs for the $100,000 fee. Now, I just mentioned a while ago that the USCIS guidance says that the petition should be denied. Well, I think we've had some scenarios here where petitions were filed before there were instructions on how to pay the fee, before this guidance was issued on October 20th, but that were pending after the guidance was issued. So adjudicators are applying it to petitions that were pending as of the date of the guidance. And because of that, because employers weren't on notice about how to pay the fee, they're issuing RFEs. So we've seen a couple of these RFEs, not enough to really have any specific information, but just enough to see that the agency is starting to implement this rule. And the RFE indicated that the petitioner must respond to the RFE with proof of payment or proof of an approved national interest exemption. And again, that it must be done if payment is done through the pay.gov website. Now, the one thing I want to say about this before we jump out of this topic entirely, actually, let's move on. Actually, no, let's move on to the last slide on the H-1Bs. So as Matt mentioned, the litigation, both lawsuits are requesting that the respective federal courts enjoin the implementation, again, because fees typically are only raised by Congress or through a detailed regulatory process that can often take years. I think one of the reasons that the litigation has been somewhat slowed in terms of reaching an injunction is because, one, USCIS wasn't enforcing it. Petitions were getting approved in virtually all scenarios. And the RFEs that we've seen in the last few days are the first evidence that the agency is starting to implement the rule. So the challenge that the litigators had was that there was no way to allege immediate harm if the agency hadn't started implementing it. So in a sense, and I know it's kind of counterintuitive, in a sense, these RFEs may be positive in that they may push the litigants towards getting a hearing on the injunction sooner rather than waiting maybe until early next year in advance of cap season. So there is, I think, some mixed blessing here, although it is clear that in certain scenarios, the agency is starting to implement the fee. But again, we remain strongly convinced that this is an illegal fee and it will be enjoined despite efforts by the agency and the White House to kind of craft this as a travel ban. It really is an illegal fee, and we think it's going to be enjoined. Matt, any other comments?
No, I mean, there's a lot of additional detail right here, but again, I think an injunction here is very likely over the next few weeks. So we'll certainly keep everybody updated. A great reason to register for our newsletter, as we'll send you those weekly updates on Fridays. So let's switch gears here and talk about increased DOL scrutiny of H-1B employers. Now, to be clear, the Department of Labor has always had a bit of oversight over employers on who employ H-1B employees through the wage and hour division. They would file LCAs with them. They set the prevailing wages. There was a provision September 19th, announced Project Firewall that prioritized additional investigations from the Department of Labor. In that announcement, really, it's focused on protecting American workers' rights. Penalties include, back pay, civil fines, debarment from the H-1B program. Again, the Department of Labor has always been able to do this for employers, but it seems that maybe they're devoting more resources to these investigations or having them happen more randomly. In my experience, Mike, I've only ever really seen these investigations happen as a result of an employee complaint, or perhaps a former employee complaint. Have you seen it any differently?
No, I think that's exactly what has been the case. And I think that's partly the reason for this renewed focus on DOL labor condition application compliance. It certainly was dormant for most of my career. It was complaint driven. And I think what I'd emphasize is that they're going to be looking a lot more deeply than just are all the right pieces of paper in the LCA public access file. I've already heard anecdotally one story. An H-1B worker was interviewed in connection with FDNS site visit, and the employee, well-intentioned employee, started sort of puffing their job duties and their responsibilities and making them sound like maybe they were a little bit more senior and a little bit more responsible than they might actually be. Lo and behold, the agency said, well, you sound like a level 4 employee. Why did the company only list you as level 2? And now that has started an investigation as to whether that LCA was accurately and properly prepared. So that's the kind of thing, that's an example of what we may be seeing more frequently in the future. In-person investigations and inspections and efforts to determine whether or not the information that is in the LCA actually complies with the facts of the individual's employment.
Yeah, I mean, this could take the form of wage and hours showing up at your place of work. Could be phone calls or emails, initiating an investigation. You'd likely have to hand over, obviously, public access files for H-1Bs. But Mike, I think they would be with in their scope to request things like payroll records, timing sheets, interviews with folks inside the organization if you're ultimately investigated.
Yeah, I would say keep in mind that the whole goal here is to protect jobs for U.S. workers. So they're going to look at this from the perspective of, did the employer engage in activities that disadvantaged or discriminated against U.S. workers in the hiring process? So that's why Justice Department is involved. They could file sort of an investigation into whether or not there was discrimination, and then that brings in not just DOL, it brings in DOJ.
Yeah. I mean, also, you have USCIS, which has the Fraud Detection National Security Unit, FDNS, which serves a somewhat similar function to this DOL, an increased DOL scrutiny, although two different agencies. Again, I think to Mike's point, highlighting that USCIS is really ramping up, and so is DOL on enforcement. So international travel guidance for foreign nationals in the United States right now, this is sort of the meat of our, so that, excuse me, that probably, it's a good segue there. I know there's some additional questions there. We'll try to get to them at the end of our webinar today, but we're going to switch gears to the meat of what we were trying to cover last month. We're certainly going to try to cover it today. That's you have a lot of folks that are traveling during this period of time with all this uncertainty for the holidays, Thanksgiving, Christmas, various other holidays. So we wanted to review with everybody, our updated guidance around travel. Given all the various factors that we're discussing, uncertainty that surrounds international travel right now. So Mike, do you want to in-person consular appearance requirements? Again, the stand to give everybody a precursor here, individuals have to travel abroad with a new approval notice, typically on an H-1B, fill out a DS-160, schedule a visa stamping appointment at a U.S. embassy or consulate, attend a visa stamping appointment in person, get a new H-1B visa stamp or L visa stamp or E-3 visa stamp, whatever it may be, and then use that to re-enter the United States. That visa stamp is only good for re-entry into the United States, and thereafter, individuals are issued an I-94 by CBP, which controls their status. So that's the current process of how generally everybody in the United States, everybody from outside the United States gets into the United States. There are a couple exceptions for Canadians, and there's different types of entry that don't require a visa stamp yet, but we're going to focus on the visa stamping process as it affects your H-1B, your L, perhaps your TN, your E-3 visas. So Mike, go ahead.
Yeah, I think that this is something that is just going to add a layer of complexity to individuals who are thinking about traveling over the holidays. So just to step back for a second, largely because of resource limitations, the State Department had implemented a series of interview waiver rules that effectively allowed individuals who had expired visas to reapply without an in-person interview if the visa hadn't expired within the last 4 years. And then that number was reduced to 1 year. And then more recently, it was almost completely eliminated. The only groups that are still eligible for interview waivers are essentially certain groups of diplomats, as well as B1 and B2 applicants whose visa had expired within the last year. And my understanding from talking to folks who work a little closely with the State Department is that that's primarily because the World Cup and the Olympics are coming to the United States within the next year. So that's to help them manage the anticipated significant increase in requests for travel authorization. So right now, almost everyone, virtually everyone from infants to octogenarians is required to have an interview, and they're required to go to their country of nationality or residence. So there's no options really anymore as a practical matter, despite the way the guidance was worded. No consulate that I've heard of is issuing appointments to third country nationals. And if a third country national does get an interview, their applications are usually put in either administrative processing or they're denied essentially on the ground that the individual can't prove that they have a residence abroad that they do not intend to abandon. So practical effect, again, higher interview requirements across all posts, more interviews, fewer venue options means that there are going to be longer times and greater itinerary challenges for those who require travel.
Yeah, so more interviews, more folks that require interviews, same amount of slots available. This is obviously going to increase the ability to get visa stamping interviews, how long it may take to schedule those. That third country national is a hit. Now, some folks now that an individual used to be able, perhaps they were a Chinese national and they go to Canada and get an H-1B visa stamp because they were a third country national there. Now that individual has to fly back to China. And that's not only does it is the process going to take longer because there's more people that are required to go through it, but it'll be much more expensive given the travel requirements that folks will now likely suffer because previously they were going to Mexico or Canada to get their visa stamps renewed.
And while we haven't seen the increases yet for business visas like H's and L's, I think it's just inevitable. I was actually talking this past week to a former consular officer who just recently left the service, and he mentioned just that it's a demoralized group of individuals. The really experienced and talented consular officers are leaving the State Department right now. And, frankly, that's just exacerbating some of the problems because they can't train and it takes quite a while to get trained to be a consular officer, and it takes a lot of experience on the ground actually to be good at it. So it's just going to exacerbate the delays and the problems of getting appointments.
Yeah.
Moving along, I just there's something that it was announced over the summer. It's something that we need to continue to watch because it could impact how business travel is conducted going forward. There was an announcement in the Foreign Affairs Manual of the State Department that the validity periods of several categories of non-immigrant visas for many countries was going to be reduced to a single entry for 3 months. Now, just think about that for a second. You go abroad, you apply for a visa, an H or an L visa, and it's issued instead of multiple entries for 3 years, for example, it's now issued for a single entry for 3 months. As a business traveler, how do you manage that? The actual trip abroad to get the visa, if you return directly from the consular appointment, you've already used the entry that the visa provided. So you'd have to get a new visa to go again. So it'll require a lot more coordination in terms of business travel in those scenarios. So if we go on to the next slide, oops, wait a minute. Yeah, I think the next slide has some information about, yeah. Here's the website that I encourage you all to go to. Again, these announcements, these changes don't happen with public announcements. They happen on the website, and literally we have to research them to find them. So here's the website to go to before you travel abroad or before your employees travel abroad. Go here to get a visa, that is. Check this website to determine the length of validity and the number of entries that can be issued for that particular country of nationality in that particular category.
So U.S. travel in 2025 here and beyond. Again, I think, Mike, our general consensus as a firm, we're advising clients and employees and specifically is to not travel, is to avoid travel if you can, right now, given the various additional requirements of the fee, the longer lines, the additional scrutiny. And there's enhanced vetting that's happening at the Department of State and DHS, right, Mike?
Oh, yeah, I think this is something that's probably well known to many of you, but we just thought we would put it all together in one slide. The three agencies that are primarily engaged in the visa application and admission process, USCIS, Department of State, and then CBP upon entry, are all doing enhanced vetting and screening of applicants. And if you think it's just foreign students, that's not correct. They're doing the increased scrutiny of social media for all applicants. In fact, I was at a conference of immigration lawyers outside the United States last week, and we were having conversations about making sure we put our phones in airplane mode before we land in the United States, because Customs and Border Protection is not allowed to look at anything that's not on the actually in the storage of the phone. So putting it in airplane mode, make sure that they don't do that. So we're mindful of the fact that there's importance in making sure that individuals are appropriately vetted before coming to the United States. Obviously, everybody agrees with that on some fundamental level, but the level of vetting and screening that's going on, and for the reasons people are being denied admission or having visas revoked. And again, I heard a story just last week of someone, youthful indiscretion scenario where early 20s, probably had a little bit too much to drink, ended up being held by the police overnight. No charges were ever filed. Person had his visa revoked recently, and now he's hired lawyers to fight that. So lawful permanent residence, I think the guidance that we give is there's a lot of this is just fundamental common sense. Always travel with your permanent resident card and valid passport. Understand that if you're outside the United States for more than 6 months, or if you're outside the United States for over a year, or if you've committed serious criminal offenses or even not serious criminal offenses, as they just highlighted, the risks increase. So these are situations that are to be avoided. And I've been advising clients, try to avoid being outside the United States for more than 6 months if you can at all. But if you have to be outside the United States for more than 6 months, strongly recommend that you file for a reentry permit as evidence that you have not abandoned your permanent resident status.
No, just again, highlight that lawful permanent residents are green card holders. They're not citizens yet. They are in terms of rights and responsibilities, are sort of a step above folks on work visas, but not U.S. citizens who enjoy the full rights and guarantees of the Constitution. So I would not only worry about travel if you're a legal permanent resident, but I would also recommend, if you have the desire to remain in the U.S. long term, to potentially apply for citizenship, because it is sort of a more vulnerable status between work visas and all the way up to citizenship. Mike, best practices on traveling internationally. I think we just covered this.
Yeah, I think we covered a lot of that already. Yeah.
Non-immigrants. Yeah. These are folks that are on work visas, H's, L's, E's, O's. Go ahead.
Yeah, I would just say take nothing for granted. No matter how long you've had a visa or how many times you've entered, I think it's really important for you to keep in mind that you should bring with you documentation proving your eligibility, because just because that's happened in the past, certainly under the new leadership, there's no guarantee that you will be admitted routinely. And we're starting to see some evidence of that, particularly with respect to TNs at the border. But having said that, if you're doing the job that was the basis, for example, the H-1B petition, and you're still working for that employer in the same role, you should still be admitted. Don't be surprised if you get additional questions. You end up in secondary inspection. That's happening more frequently now. But as long as you're working in the capacity that was described in the petition, you should be fine. Let's go on to the next slide. Just trying to be mindful of time here. Yeah. I think, again, some of this is common sense. Ensure that the visa is valid on the date you plan to re-enter. Make sure the passport's valid for 6 months. Carry copies of supporting documents, relevant to the status. The approval notice, the employment verification letters, documents from the school if it's a foreign student. I think it's really just make sure that when you're at that kiosk applying for admission to the United States, you have in your possession everything you need to defend yourself from a claim that you're inadmissible. Better to have it and not need it, as they say, than to need it and not have it. I would have that in your backpack, your briefcase, whatever you're carrying with you on board the plane, ready to present upon request. And obviously, if you've had recent immigration or criminal issues, don't leave the United States before talking to competent immigration counsel.
Yeah, Mike, I would expand that guidance and say, if you are a foreign national working for an employer, I would let your HR person know. If you're an HR person, I would require that your foreign national employees notify you if they're traveling abroad, so that you can have, if you hopefully have counsel, you probably do, can review their situation and help them troubleshoot any issues they may face.
Yeah, and I would just add one other point to that. I think that, if, for example, you're traveling on an H-1B, not just have the documentation in your possession, but really read it and understand the information that was given to the agency about your job duties, your title, your basic responsibilities and salary. Know that and be able to explain that sort of clearly in just a few sentences, so that you can establish your credibility with the CBP officer.
Yeah, and we didn't always give this guidance, but now I think it's fair to say, try to travel with your original documentation. CBP officers, Department of State people can get fussy with that sometimes for no reason, even though it's not required. Make sure you have a valid passport at all times. Most importantly, and this was with the registration, I think that more recently happened. It seems like a decade ago right now, Mike. But make sure you update your address with Form AR11 or on your portal with the USCIS website, my USCIS. Is that super important?
Yeah. A lot of people have been having issues because of petty problems in their immigration history, and I agree with you. We have not always required or recommended bringing original documentation, but the universe has changed in the last few months, and I think it's probably better to have it, as I said, in your possession.
And make sure you update the USCIS if you move your home location. That's super important. Obviously, other general travel recommendations, Mike mentioned this before, but prior criminal history, even minor incidents, could be brought up. So if you have something, even if it was 10 years ago, we're talking about could be like disorderly conduct or possession or DUI, and some of these sort of lower level things that weren't necessarily a concern or would be a hassle at either the consulate or when you're entering, when CBP is inspecting you to get into the country, are now issues. So as Mike was mentioned here, and we're talking about, consult with counsel. If you have employment counsel, if the company has immigration counsel, make sure you talk to them before you leave the United States if you're in that situation. Mike, and CBP is authorized to inspect anybody's electronics. This is something that happened years ago. Is it happening again? Any phone, any laptop, anything you bring through customs can now be inspected based off of a national security exemption, I believe. Is that right?
Yeah, it doesn't matter if you're a foreign national, non-immigrant, permanent resident, or U.S. citizen. They have the right to inspect it. And if you decline their request, if you are a non-immigrant, you're probably not getting into the country. If you're a permanent resident or a citizen, you'll probably get in, but without your phone.
Yeah, we face this as immigration attorneys traveling in and out of the country. Which, Mike, you were just in Germany. I delete apps off my phone that I use for work, including like our box drive and other things that I have that are password protected, secured. We've discussed the potential of mailing laptops back if you feel it's necessary, rather than bring them through customs with you, as a way to keep customs and border protection from accessing all of your digital stuff. So.
Yeah, and I heard actually this past week, the question was raised about bringing burner phones, and does that create any presumptions that you might be hiding something? And State Department, former State Department employee said no, it doesn't create any presumption at all. So that remains an option for individuals who are concerned about bringing their cell phones.
So I think the last section here is just recommended best practices. We'll kind of, Mike, we can alternate here and go through these.
Yeah. I mean, I think, go ahead.
No, I was going to say, I think first and foremost, we talked about this many times, but if you're traveling, what's the reason for your travel? Do you really need to travel right now? And if the answer to that is yes, then, speak with an attorney, understand, assess the timing of your trip. What's the purpose of your trip? What are the requirements that are going to happen after you leave the United States? Are you required to go through visa stamping? Do you have a valid visa stamp? What documents should you carry with you? These are all things I think that should be discussed with HR and outside counsel, Mike. And lead times, right, Mike?
Yeah,
when folks will be traveling. I think this is where the requiring employees to give notice is really important. Go ahead.
Yeah, I think coordination is really important here. Again, as you said, I think a first level evaluation is the travel necessary, or is it just a preference? And if it's just a preference right now, is it necessarily something that's wise, it's in your best interest, or in the best interest of your job with your employer? So it's going to take longer, although right now, again, we haven't seen a significant change in non-immigrant visa wait times, particularly for employment-based visas. But I think that's going to be coming soon. And I think you really need to stay on top of the timing and the latest developments in terms of what you need to bring with you. I also there's one point of the slide I really want to emphasize, which is making sure if you're applying for the visa that your information, your application is complete and accurate. Getting your application derailed, having a heightened risk of administrative processing can add weeks to the processing of the visa application. You still may get it, but it will delay your return to the United States significantly. So make sure that you're triple checking all of the paperwork that you're submitting in connection with your application.
Yeah, for this very reason, Mike, we dusted off our consular processing product because things are getting more difficult, where you can engage us to review your DS-160 information to make sure it's accurate against your petition, provide all the required documents that you're going to need as an employee of the current client, and then also go through a 15-minute rehearsal of what the interview would be like to prepare the individual, just so it could go smoothly. We're seeing more and more of that. I would also just highlight here, coming up with contingency plans, as folks travel abroad, for when they get stuck there potentially. The 221G could get issued. It's a consular RFE. Person can be there for 2 to 4 weeks, depending on how long it takes to respond to that stuff. What do you do with the person in terms of work, PTO, VPN security, laptops, things like that. We've had to work with clients through all of those contingencies as folks have gotten stuck abroad, which is more likely now. Mike, final recommendations?
I think you just covered a lot of this, Matt. I think really the one thing I want everyone to really have in the front of their mind is, if you have someone who's traveling over the next few months, and you've had the conversation with them, you really can't preclude them from traveling, but they maybe it wasn't something that you necessarily recommended or was necessary. If they travel abroad and they get stuck, what's the company policy? To what extent will you support an employee who's stuck abroad in administrative processing when they've traveled at their own initiative? And I don't know if there's a one size fits all answer to that, but that is something that probably needs to be discussed with the foreign national in advance of their travel, maybe letting them know, hey, I appreciate you wanted to see your family over the holidays, but if you're not able to get back to the United States in a routine period of time, here are the consequences of that. I think that's a conversation that has to be done upfront. But other than that, I have no other comments.
I think we've seen most of our clients really make a decision tree based off of whether the travel is elective and personal to the employee or whether it's something the business is requiring, and kind of like using those initial questions to dictate what happens if the individual gets stuck abroad. We appreciate everyone for joining the webinar today. I think we have 3 minutes left, so. Right. Something we didn't touch today, Mike, and I think is important to talk about: the government shutdown. So it's become almost so normal that we're not really thinking about it at all times. There's a question here. When do we think the government shutdown will end? And will the flag site get reopened? For folks that don't know, the flag site is where we file prevailing wage requests. I believe perms right now, LCAs for H-1Bs, which is why you can't file transfers or extensions because it's closed. What do you think, Mike? What's your?
My crystal ball is my crystal ball is very cloudy on when the government shutdown will end. I frankly am embarrassed as a U.S. citizen that this is what our government has come to. When the flag, when the shutdown ends, whether it's on a short-term or longer-term basis, flag will reopen almost immediately. Their backlog will probably increase significantly because of the pent-up demand. So I would expect whatever the processing time was before the shutdown will increase by a factor of maybe twice the amount of time it's closed. So if it's closed for 6 weeks, then maybe the backlog will increase by 12 weeks just because of the pent-up demand and the prior demand that was pending on the day of the shutdown. I have no evidence to support that. It's just my impression that it won't be business as usual for a while.
Yeah. My hope is that they open the government in the next 30 days or so. I think that there are various constituencies that are going to start really feeling the pain. One, military families, food systems programs. There's going to be a lot of things that I think fall off the cliff here in the next week or so. My hope is that they'll come to some type of agreement to reopen the government in the next 30 days, but we'll have to wait and see. Mike, a question we've got a few times that I want to clarify about the H-1B lottery fee. Quite a few questions about that today. If we have an H-1B employee, an employee that's on OPT, they're a student, we've recruited them out of school, we've hired them, they have their OPT EAD or their STEM OPT EAD, and we're submitting them in the lottery next year for selection. Will that individual incur the H-1B fee, the $100,000 fee, if they go through the lottery, based off current advice?
Yeah, first thing I want to point out is that submitting them in the lottery process will not cause you to be responsible for the fee. If they are selected in the registration process and they are in valid OPT status, and you're filing for a change of status from F1 to H-1B, they will also not be subject to the $100,000 fee if that change of status is approved by USCIS, which in the normal course it should be done. So that person will not be responsible for paying the $100,000 H-1B fee on filing of the petition, nor upon applying for the visa abroad based on the current guidance. Caveat, it's guidance, it's not a regulation, it's not a statute. Policies can change over time at the agency. But I think if you're asking me today, at this afternoon, I would say that person would not be subject to the fee.
Yeah, and I would say that the fee is likely to be enjoined by then or stuck in litigation, so maybe not apply at all, but we'll see going forward. We have another minute or so here. For folks that are impacted due to the shutdown, let's say, my H-1B is about to expire, but I can't file my LCA. What should I do, Mike?
Yeah, in prior years, in prior shutdowns, I should say, USCIS has issued guidance saying that they would accept petitions without a valid LCA and then issue an RFE once DOL is open for business again. USCIS did not do that this year. The only guidance they've provided on their website, somewhat cryptic, saying they would take the shutdown into consideration in determining whether a late filing may be excused. So
Yeah.
many of us are taking that as filing now could very likely lead to rejection of the petition. And we're planning on filing these petitions with clear statements of why it was filed late when the shutdown ends.
Yeah, so there's something called non-pro-tunc, which we use a lot when we have to file means now. For then, I would file a non-pro-tunc petition as soon as the government reopens with the certified LCA from the Department of Labor saying we're filing now, but please forgive the extenuating circumstances of government shutdown. It should be considered as properly filed back then, whenever the H-1B expired, for example. I think that's about it. There's a couple other more specific questions right now, but I think we're running it right up against time. So we really appreciate everybody. We've had a ton of attendance, several hundred people attending these webinars. So if you know anybody that's interested, feel free to give them the link to register. We're going to continue to do this. Also a reminder to register for our weekly newsletter if you want to get weekly updates instead of monthly. And we will be back next month to cover all the hot topics, as well as, I'm sure, Mike, as you can probably be aware, some unforeseen changes that we will be discovering at that point. So thank you so much for your time today. Have a wonderful week, and we'll talk to everybody next month. Take care.
Take care.